So let's at least quickly touch on some of the pitfalls to avoid in estate planning and just kind of some of the recurring themes that we see with bringing families into probate court. In truth, this was kind of a hard module to aggregate because as probate attorneys, we see so many different ways that issues can come up and pitfalls that occur that it's hard to really categorize them. But there's definitely recurring themes. And I think that the top four are probably easiestly said as having no plan. That's an easy one. Having the wrong plan, having a failed plan. Those kind of go together. And falling for the too good to be true story. So having no plan, that's pretty straightforward. If you don't have a plan in place, your family goes to probate court for a judge to decide who gets what, based on then existing law. Now, compared to some of the things we'll talk about in a moment, that may not be the worst plan because at least everything ends up with the kids. And in general, California law follows what would be considered a natural inheritance, order as is. But it's still not a good plan. It's better for you to say who gets what and how that happens. Take control of your estate rather than leaving it to a judge and attorneys to decide later. So having no plan is definitely one of the big pitfalls. Having the wrong plan is also an issue. And there's all kinds of iterations out there. Someone who set up a will-based plan because they didn't know they needed a trust, but they actually needed a trust-based plan to avoid probate. And this can just be bad advice was given during the planning process, or no advice was given. It was just own research on bad sources, or unfortunately, a friend just told them wrong. It can also be something as simple as, and this is a very common one, someone says, I don't want to pay for a trust. I don't really care about anything. I just want the house to go to the kids without having to go through court. And then here comes their friend and they say, well, you don't need a trust. Just put your kid on title of the house, or just transfer it to the kids while you're living. Just do a deed, a quitclaim deed. And this is where half-truths hurt you. So yes, it is true that if you put your kids on title, they're going to avoid probate. If you name them as joint tenants, they don't go through probate court. The downside to it, and if you go back to refresh the capital gains talk in the taxes module, the downside to putting your child on title with you while you're alive, or a lifetime gift, is that does not come with the step up in basis for capital gains taxes. So if you transfer a highly appreciated house to your kids by way of a deed, joint tenancy deed, instead of by way of a trust or a will, they are inheriting a massive tax liability that's completely unnecessary. You can quickly cost your kids hundreds of thousands of dollars that way. So having the wrong plan is probably worse than having no plan, in all honesty, just depending on which plan it is. That's where you really want to make sure that if you're going the DIY approach, that whatever software you're using has the resources to teach you about the basics, break down what type of plan is right for you based on common scenarios, and then make you comfortable with the plan that you're pushing forward with. And if you don't have that, it's always worth it to hire an attorney to make sure this decision is done properly as well. Now, the next one is a failed plan, and this one is extremely common, believe it or not. Less common when an attorney is used, extremely common when someone tries to DIY or use a software to do their estate plan. And usually it's when you find the cheapest product out there that spits out a trust document or an estate plan, and you just don't know what to do with it. And we see it all the time where a trust is signed, but there's never anything put into the trust. It's not technically a failed plan in that usually there's a way to salvage it through a petition in court. The problem is we have to petition court, and that's the whole purpose of the trust, is to keep us out of court. Now, other failed plans are like the true DIY approach, where someone just starts writing out a plan, and on paper they have a security blanket. They feel good. They've got something that says trust, but what's in it is just, from a legal perspective, ineffective or just outright doesn't work. And we end up in court to fix the issue. So again, no plan, we're in court, but at least it's going to be orderly. If we do the wrong plan or have a failed plan, it can almost be worse depending on what the issue is with how the plan was set up. It can almost be worse to undo something done improperly than just not having a plan at all. So just something to consider when you're setting up a plan on your own through a software that doesn't have all the support that you need. If you go through the estate lock route, I'm confident that all the guidance, all the support, videos, written instruction, everything is there for you to get your plan done in a way that's going to protect your family. But when you're out on the market for a done-for-you software, be leery of the cheapest thing out there. A lot of times that's where you'll see the nightmares of a trust didn't work because there wasn't the proper guidance on how to fund the trust, which we'll talk about in the next module. Now, the final thing is you fell for the too good to be true story out there. And I didn't know what to name this one. I couldn't come up with a catchy thing. But this is, and I'll be honest, I have to, with the invention of TikTok, I'm astounded by how much bad information is out there. But someone is selling a purported trust that makes it where the IRS will never take your assets regardless because you have this kind of trust. Or you have this constitutional bulletproof trust, and if you put stuff into it, no one can ever touch you. Almost entirely complete hogwash. It's nonsense. Unfortunately, people fall for it. We've personally dealt with clients who have trusts according to the laws of Narnia that don't exist, or they've put property into these land patent ideas that have no legal grounds and have been refuted over and over again. But they fell for whatever the snake oil salesman was selling, unfortunately. If something sounds too good to be true, as with most things in life, it probably is, right? If someone is selling you something that is super easy for you to retain control, it doesn't change how you deal with everything on a day-to-day, no one can ever touch your assets, you have complete anonymity, the IRS can't even come after you, you can divorce your spouse and they won't get anything from you even though you're in a community property state. Be very leery of any of these kind of things, especially when they're priced in like a few $100s or something. Completely walk away, full stop. Don't do it. Go and talk to an attorney about it. You don't even have to engage an attorney. Usually send them an email, set up a consultation. They'll talk through you at least about the basics and walk through why that purported scheme is not going to work. So definitely have, the red flags waving when someone's selling you something too good to be true. Now, to make sure that we avoid a lot of the issues we've talked about in here, let's talk about funding your trust in the next module.